and good evening to everyone. I'm Natalie McSherry. I'm the president of the MSBA, and it's my pleasure to welcome you all on this very special event. Tonight, we, the members of the MSBA, and more broadly, the members of the legal profession, embark on a collective journey, one that is both vital and timely, as part of the commemoration of the Maryland State Bar's 125th anniversary. This milestone anniversary is more than just a cause for celebration. Indeed, it is an invitation for critical reflection on the legal profession by the MSBA as a nonpartisan professional organization. What binds all of us together is that we are part of this noble profession. And so what we will do is spend time critically reflecting on how our profession has wielded its position of influence historically, and how we might exercise that influence going forward in relation to advancing justice in our state, our nation, and the world. This desire for deep reflection has led to the creation of the 125th Thought Leadership Initiative, which by design is intended to spark intellectual curiosity and stimulate robust and respectful dialogue, and ultimately profound introspection and meaningful action. The initiative, spearheaded by our fearless leaders, Donna Hill-Staton and David Shapiro, has been constructed around 4 themes, all of which will grapple head-on with our checkered history in creating and enabling racial and other inequities. The themes will explore, first, our ethical obligation to serve as guardians of justice. Then, our commitment to ensure access to justice for all, especially those who cannot afford an attorney. Next, our responsibility for reforming justice to correct racial and other inequities. And then our charge to prepare for the next frontier in science, technology, and justice. Over the course of the spring, we will set the table and invite innovative thinkers and fierce leaders under the banner of each theme to help ground us, help us reckon with our history, and help us reimagine a just and equitable future for our systems of justice and our role as legal professionals in those systems. And there is no one better able to help us launch this initiative than the internationally renowned leader, advocate, attorney, and media personality, Ms. Sherrilyn IfillFull. Ms. IfillFull is the president and director counsel to the NAA Legal Defense Fund, the nation's leading civil rights law organization fighting for racial justice and equality, which was founded more than 80 years ago by then future Chief Justice of the Supreme Court, Thurgood Marshall. Ms. IfillFull has too many accolades to her name for me to list them all, so I will mention but a few. Ms. IfillFull was named one of Time Magazine's 100 most influential people in 2021, in part for being, and I quote, the rare strategic lawyer who has the ability to inspire, educate, and disassemble the distortions and misguided analyses that often paralyze policymakers. She's also one of the teachers for the new masterclass on Black history, freedom, and love, and has received the 2021 American Bar Association Spirit of Excellence Award. She was selected as the 2020 Attorney of the Year by the American Lawyer, and was even named one of Glamour Magazine's 2020 Women of the Year. In 2021, she was appointed by President Biden to his commission on the Supreme Court. Ms. IfillFull is a prolific scholar who has published academic articles, op-eds, and commentaries in leading law journals and newspapers. She's a frequent guest and commentator on TV talk shows, and her 2007 book, On the Courthouse Lawn, Confronting the Legacy of Lynching in the 21st Century, is highly acclaimed and considered foundational to the contemporary discourse on lynching and reconciliation. On behalf of the MSBA, I want to express my deep gratitude to Ms. IfillFull for joining us and for her sincere interest in engaging with our bar on the issue of our unique and unparalleled role in upholding the rule of law. And now, without further ado, I am happy to turn the mic over to my good friend, Donna Staton, who will serve as the moderator for our discussion with Ms. IfillFull. Donna?
Natalie, I thank you very much for that introduction of our very esteemed guests. I'd like to welcome everyone tonight. And just to add, before we get into the conversation, just to add a little bit of information in terms of background to help you get a sense of where we want to go with this conversation tonight. As we all know, lawyers are central players in the story of American democracy. And our profession wields outsized influence over the lives of others from positions of both privilege and power in the institutions that form the pillars of our democracy. In addition to a near monopoly on the judicial branch, we count among our numbers 25 of the 56 signers of the Declaration of Independence, 22 of the 55 signers of the Constitution, 53% of the first US Congress, 60 to 80% of Congress in the 19th and through half of the 20th centuries, and 27 of 46 US presidents were lawyers, and as of 2020, 17 sitting governors had law degrees. So from the country's inception to present day, lawyers assume roles integral to how our country's laws are made, shaped, interpreted, and enforced. And we've been bulwarks against assaults on the foundational ideals that make us the world's model democracy. But sadly, we've also been accomplices to some of the greatest perversions of civil rights. And it's against that background that we've embarked upon what we hope will be a year-long exercise to reflect about these realities. And Sherrilyn, thank you, thank you, thank you. I know that you're a New York native, but you should also know that Maryland claims you as its own. And we couldn't be more proud of the work that you've been doing on our behalf and behalf of all citizens to defend democracy. So thank you. When I called you and reached out to you about doing this program, once I was able to catch up with you because you're quite busy, your response was almost immediate in terms of saying, I would be very happy to do it. Can you tell us about what resonated with you in terms of the programming that we're undertaking? And you help us kick off.
So much. And thank you, President McSherry, and thank you, Donna. You know, first of all, there's nothing you've ever asked me or would ask that I would say no to. So that, you know, it was a foregone conclusion. And I'm really delighted that so many people have joined us this evening. I know you could be doing other things. And so I'm really glad that you're here. Yes, I first started practicing in New York as a civil rights lawyer in 1988. I came, as many of you know, to Baltimore in 1993. And the one thing that wasn't mentioned was that I taught for 20 years at University of Maryland Law School. I have no doubt that some of my former students are on tonight. And I considered it a great privilege to be able to educate essentially, you know, the people who would be the lawyers of Maryland, you know, for decades to come, literally thousands of students. Long after, even after I had tenure and didn't have to do so anymore, I insisted on teaching civil procedure in the first year because I wanted to reach first year students. I wanted to have them feel the kind of enthusiasm I have about being a lawyer. I wanted to give them a sense that this course that so many people deride is actually incredibly exciting. I wanted to talk about the relationship between rules and procedure and substance. And I wanted them to see me as a Black woman teaching this important subject. And the reason it was important to me is because I have always taken very seriously being a lawyer. I'm incredibly proud of it. I'm the youngest of 10 children. I'm the first and only lawyer in my family. My family's very proud of me. There's one lawyer and one doctor. And we take very seriously the struggles of our parents and our families to put us in position to be able to live the lives that we're living and to achieve these dreams. It was always understood in our family. I always, used to tell my cousin Gwen that the family business is service, that we would use this to better the lives of our people, the lives of our communities. And so I wanted to be a civil rights lawyer from the time I was a girl. And when you called me, Donna, I had been, well into, for the last year and a half, thinking very deeply about our profession. And as part of my broader thinking about what I regard as the crisis in American democracy at this moment. I was on a Zoom today for Martin Luther King Day at the Department of Justice with the Attorney General and the Associate Attorney General. I talked about the crisis in democracy. And if your democracy is in crisis, one of the first things you should want to examine is the state of the rule of law and the state of the legal profession, because the rule of law is such a critical component and the legal profession is such a critical component of a healthy democracy, not just in the United States, but everywhere. Lawyers have outsized power. We are leaders, even when we haven't earned it. And around the world, whether it was Nelson Mandela or Mahatma Gandhi, lawyers have been at the forefront of even changing how we think about justice and equality and fairness. So I know the power we have. And so if your democracy is ailing, is sick, is unhealthy, then you have to look at the state of the legal profession. And to my mind, I see some very serious and concerning issues that I think we need to grapple with.
Yeah. I appreciate that, because the next question was going to be to you. When we were struggling with figuring out what to call this particular event, we came up with democracy in peril, but I'm sure that there are many folks who looked at that and said, oh, that's a lot of hyperbole. What is that about? Or is it, being political? What is that about? From your perspective, you're on the front lines. What are we really facing a crisis at this time? And is it different in kind than where we've been at other points in our history?
I often, deride people who kind of cynically say, everything's the same as it always was. But I also am careful not to suggest that, people have never seen before what we're seeing today. But I do think there is a difference in this moment. Mm-hmm. And I can comfortably say that as a civil rights lawyer, because I've been a civil rights lawyer now for 30 years, over 30 years. And so I've practiced this and worked, on behalf of people who are the most marginalized for decades across a variety of political periods, across a variety of presidents, across different governors, of course, across the political spectrum, different economic situations. I was at this job during the tenure of the first Black president. And so I've been able to see it. And there is something actually quite different. And I think the part that is really different and frightening is that, and for a lot of reasons of which I'm happy to talk about, I think we've lost a shared sense of the importance of being a democracy. I think there are literally at this moment tens of millions of Americans, citizens who are agnostic, actually, about whether we are a democracy, agnostic about whether the rule of law is applied equally to the prominent and to the low. They are agnostic about, whether we have to address the issue of armed agents of the state engaging in misconduct and even taking the lives of innocent and unarmed people. They are unconcerned with not only whether some people don't have equal access to vote, but they are unwilling to accept the outcome of an election if it doesn't go the way they want it to. they are willing to deride judges who rule against them. And I think that's different in kind than what I have seen. I know people say it's just partisan politics, and I can tell you it is not. When I started out as a civil rights lawyer at the Legal Defense Fund, the first case that I filed myself, voting rights case, went to the Supreme Court in 3 years. So here I am, about as naive as it gets, but trying to do this case. And, the then director of the Legal Defense Fund is going to argue the case in the Supreme Court. I'm going to get to sit at counsel table. I'm writing the briefs. I'm doing my thing. But what I remember most about that experience is that there were two consolidated cases. One was called Chisholm versus Edwards. The other was called Houston Lawyers Association versus Texas. And that second one was my case. I was a counsel on the team with Chisholm as well. And in the Chisholm case, our co-counsel was the Department of Justice. And in the Houston Lawyers case, the Department of Justice had asked for argument time and was arguing on our side. And I remember being in the Solicitor General's office and talking about the argument and negotiating the arguments. And the Solicitor General was obviously not taking the same positions that we as civil rights advocates were taking, but we were on the same side, and they were arguing in favor of an expanded vision of the Voting Rights Act. And they argued on our side, and we won both of those cases. And that Solicitor General was Ken Starr, because there was an understanding at that time of the importance of the Voting Rights Act, of the importance of civil rights enforcement, the importance of the Department of Justice's role in civil rights enforcement. You fast forward and to the last administration and Bill Barr, and there was essentially no aggressive or affirmative civil rights enforcement, let alone co-counseling, let alone arguing in the Supreme Court. And there was hostility to voting rights litigation, and there was condoning of, I'm leaving aside the big lie now, I'm talking about in 2017 when the then President Trump insisted that although he won, there was voter fraud and that there were 3 million ballots that hadn't been counted because he couldn't believe that Hillary Clinton had won the popular vote. And instead we had a Department of Justice that went along with the creation of an election integrity commission that later had to be disbanded. So things have changed dramatically. One of my board members said, one of the problems we have in this country is that we don't sit at the dinner table and talk about these issues anymore. And we don't talk about terrible things that we see. And I had to push back against him. And, he and I are both students of civil rights history. And I said, well, listen, I love the story about the Sunday night that Judgment at Nuremberg was playing on CBS for the first time, and that CBS broke through with a special report. Now special reports are all the time, 24/7. But then, as you all remember, back in the day, special reports were a big deal. And they cut through with the special report to show what had happened that day on the Edmund Pettus Bridge. And it is long believed that that night that America seeing, at having being in the middle of watching Judgment at Nuremberg about Nazi Germany, and then seeing the beatings on the Edmund Pettus Bridge, it was a wake-up call for many people in this country who said that's not who we want to be. And I reminded my board member that, yes, but we have all seen. It's not that we don't have images now that should distress us. We saw Walter Scott running in a park, being chased by the police and shot in the back. We saw George Floyd being killed, and it was a moment of tremendous excitement to me to see tens of millions of Americans come out onto the street after seeing the torture video of George Floyd being killed. But we're here a year later. There's been no legislation. When we have our tally of police killings, it's the same number that it's been. And so I think that we're in a moment where, for lots of reasons, some of it social media, we've lost our sense of outrage, and we've lost a shared sense of who we want to be in the world. President Eisenhower was an opponent of segregation, but he called out the 82nd Airborne to Central High School in Little Rock when Governor Favres had the National Guard try to bar those children, the Little Rock Nine from being able to enter the school because he knew it was the right thing to do, because he cared about America's standing in the world. And he thought that if we were going to be a leader of democracy, and of course this was during the Cold War, that it was critical that those images not be sent around the world of what this country was about. And so I think, yes, things have changed.
Well, when we think about the life of our democracy, of our republic, I mean, isn't it, the case that we've always been a democracy under construction? Because from its original founding, in the Constitution that provided that Black Americans were 3/5, of a person, that was an imperfection that was kind of built in, or a defect that was built in. So, we have always been dealing with
Yes.
that reality, but is the difference that people actually embrace the idea, even if they were deluding themselves, but they embrace the ideals of a democracy and we're open to working towards that, versus what you're describing, which is a very kind of different term when you talk about people being agnostic. Is that something that you're observing?
I mean, I would say, to be honest with you, I don't count this country as a real democracy in the sense that I would be considered a part of, and certainly not before 1954. You can't have literally legal apartheid in half the country, which is what we had, and call yourself a real democracy, right? So, so even if we start counting from 1954, some would say not until 1965 when the Voting Rights Act was passed. And I embrace that analysis because it helps me, and I think should help others understand that we're a very young country, at least a young country in terms of what we say we're about and what we're trying to accomplish. In terms of being a country that even, in imperfect, of course, could call itself a democracy, it's not been very long. It's like 67 years or so, and that should explain to us why we have so many growing pains, why there's so much work to do. And I think the narrative we've all been told is that, I remember being a kid and having my bicentennial quarter, and, it was like we were, an older country. And in fact, for the country that we're trying to be, which, by the way, is an ambitious experiment that really has not been successfully accomplished elsewhere in the world, a true multiracial democracy. We're doing something very unique. When the 14th Amendment included birthright citizenship in its first line for the purpose of ensuring that Black people would be citizens, both newly freed slaves and free Black people who had basically been rendered stateless by the Dred Scott decision. The first line of the 14th Amendment corrected that, but that wasn't the norm around the world. That wasn't the norm in Europe, that if you were born in the country, then you were automatically a citizen. You were French because your parents were French, or because you were German because your parents were German, and so on and so forth. So this has been very experimental. And I think we have deluded ourselves into believing that we are stronger in the foundations than we truly are. There's so much work to be done. And I hope that seeing the fragility of our democracy over the last number of years, I hope will help people to see that we have to roll up our sleeves, and not just the professionals. To be a civil rights lawyer is to constantly be working on democracy. When Thurgood Marshall was litigating the case that became Sipawell versus Fisher, Sipawell Fisher versus Oklahoma, University of Oklahoma Law School, he was seeking to desegregate the University of Oklahoma Law School. And I often tell the story about that I heard from Ada Sipawell, the plaintiff herself, when she was trying to integrate the law school, that after the first day of in the hearing in court, they were packing up their things, and they were so hungry. And because they had not anticipated or thought through the fact that they would not be allowed to eat in the cafeteria of the courthouse. And Marshall said, okay, well, tomorrow I'll try the case and you bring the bologna sandwiches, and, big laugh, but not so funny. But it goes to your point about, you said delusion. I don't think of it as delusion. It's about imagining and fighting for something that doesn't yet exist. You know, there was no place in the world that you pointed to and say, oh yes, we want to be like that. That's not what civil rights activists were doing. That's not what Thurgood Marshall was doing. They were using the words of the Constitution itself and demanding that it be fully realized and true. And whether we talk about women's rights or LGBTQ rights, that's what civil rights is about. It's about imagining that world and then working for it, even if you personally are not experiencing it. And that's what makes the work so noble. That's why I love doing what I do. So it's a uniquely kind of hopeful work. But that's just one part of this particular profession. I actually think that being a lawyer and taking the oath that we take, I always felt proud that it unites us in a way, no matter what kind of law we're practicing. And I remember in the early days when I was, litigating cases in the South, and, I would argue maybe in the Fifth Circuit Court of Appeals, and at the end of the argument, maybe the opposing counsel was usually a lawyer for the state would come over, and sometimes we would shake hands, and, and then we would all go and we'd meet up with our clients, and my clients would say, oh, how could you shake hands, with him or her? Oh, they're so terrible. And, but if that lawyer, and in those days they were, follow the rules, they were polite, they made their argument. I used to say to my clients, they're enrolled. I don't actually know anything about him personally. He's doing his job. He works for the state, and, he's making those arguments for the state, and we're making our presentation, and there's a system that we're a part of. I don't shake hands with him because he's my friend. I shake hands as an acknowledgement that we have played, each of us, fairly in the system of which we are both a part. I've always taken that very seriously, being an officer of the court. I will tell you that does not happen now. In our cases, I see our young lawyers, and it's concerning to me, not because we would rebuff them, but because the kinds of arguments that are made, the performance and the behavior often of attorneys in litigation is so much cruder. But we always work at trying to maintain that high level so that we can always feel that we are respected. And we found this to be true, regardless of, we see a lot of judges, and because we work in the South, many of them are conservative, but we always hear really powerfully affirming things to our lawyers about how they presented themselves and performed in the courtroom, because we consider that so important. So it's not really, to me, just about the job of civil rights lawyers. It's about, as a profession, we all share the job of upholding the rule of law. And if the rule of law is teetering, and if there are people who believe that it shouldn't apply to everyone, if we see misbehavior by government attorneys, if we can't trust the word of the Attorney General, if we don't have lawyers who refuse to make arguments that have no basis in fact, and who make representations to the court that are untrue and do not attempt to correct those representations, that is a problem for all of us. That is not a problem for any particular party or for civil rights lawyers. It is a weakening of a foundational pillar of a healthy democracy.
So, with all of those observations about, what you're seeing now and how things have changed, particularly with respect to how we engage as a profession, do you see opportunities for us to improve, to change, to reconnect about what are or should be our shared values as a profession?
Well, I hope this will be the start. In Maryland, I have been calling for this. I've in the ABA and the ALI and in our professional associations. I think this is our job. I think it's our obligation. People are always asking me, what can I do? It's a privilege to be part of this profession. People look to us for leadership, and our silence speaks volumes. And so, yes, I do believe it begins with self-examination. It begins with examination of the history of our profession. I just told you a story about, Marshall not being able to eat in the courthouse, right? And, last year, I guess it was several years ago, when, suddenly judicial nominees, federal judicial nominees nominated by President Trump would appear before the Judiciary Committee and would be asked if Brown versus Board of Education, was valid and was constitutional. And dozens of them demurred. I mean, something that had just not happened before. They just would not say it. They said they couldn't comment on it. Now, I think that probably all of us who went to law school at a certain time understood Brown to be one of the highest moments of our profession, and understood that it has come to be part of the canon of American law. It is a platform upon which we can say the kinds of laudatory things we can say about this country being a place of equality and opportunity. And when you say that as a judge, as a judicial nominee, that you can't say that, then I can't be sure that will I be able to eat in the cafeteria of the courthouse? I mean, do you think that's a problem? We all know that the courthouses in our very state were segregated. We know that Black jurors were prevented from serving long after Strouder versus West Virginia in the 1800s. We know that truth. And we need to confront that truth and handle that truth and understand how far we've come, even as a profession, in terms of our own character and standing up for the rule of law. I've obviously written about this in my book about lynching, about the role in particular of lawyers and the legal profession.
And I think with, just in talking about that book, if we take a hard look at where we failed to speak up and speak out and the consequences of that. I mean, the work that you did in that book, where you talk about the lynchings, but not just the lynchings, but how a community coalesced around each other to basically come up with different narratives about what occurred. And that support came from the leaders in the legal community. And that's something that we really, we never reckoned with in terms of their conduct. And do we have that kind of, the kind of review that should have been invited at that time today, where we have any number of examples of where we're failing to stand up as a profession?
I absolutely, the hardest parts of that research, I can remember the day I found in the Pratt Library the book that had something I had been looking for. When George Armwood was dragged from the jail in Princess Anne and stabbed and hung and set on fire, and there were, some believe, 2,000 people who were present. It was understood that it was going to happen. He had been taken from Baltimore back to the Eastern Shore. So this was not a spontaneous lynching in a sense. And I had heard stories about people knowing some of the people who were involved in the lynching. And I would say my book was not about that. It was not a true crime story. I was not on a manhunt. I actually was trying to engage the question that you began to allude to, which is how does a community close ranks around one of the most horrible things that could happen to a human being, the burning of other human beings. And I wanted to also get at why lynching had such a powerful hold of terror in my own community. And the reason is not only because it is a terrible, awful way to die, but because of the randomness, but more importantly, because in my community, we understood that the white community would close ranks. And that's what made it so terrifying. So I wanted to understand that a little bit more. And so I'd heard that, people knew who were some of the people who participated in the lynchings, and that in fact there were, some witnesses, and the DA at the time had indicated that, he didn't have enough evidence to try to arrest anyone. This lynching in 1933, October 18th, 1933, occurred 2 years after the lynching of Matthew Williams in Salisbury in Wicomico County. And, and so there was real concern about this, including by the governor and the attorney general. And so the attorney general was appointed to come and investigate. And what the attorney general found is what I was looking for. And it was in a book in the Pratt Library. And what the attorney general found were that the affidavits of so many witnesses to the lynching, including state troopers who had been called out, and who, swore out affidavits saying, I saw this person. I recognized him because he's an amateur fighter and I've been to his, boxing bouts. He was one of the people who dragged him, Armwood down the street. That I recognize this person, right? So he's got sworn affidavits from state troopers, but said he couldn't, the local DA, that he didn't have enough evidence to prosecute. That was a very, powerful and painful moment. So when you see this distrust in my own community about the legal system, it emanates from that, but also from their current experiences. And I've shared this often. I shared it with the president, both, actually two presidents, with both President Biden and President Obama, that, I'm the rule of law person. When a terrible incident happens involving a police killing of an unarmed African-American, I'm taking the care. I'm watching the video from all angles. I'm looking at the police report, right? I'm not, I always say, LDF is second on the scene, because we're not the first, because we're not going to be out there talking if we don't know what we're talking about, right? I'm looking at the statutes. I'm trying to understand what happened. And by and large, we are always trying to support the process, right? We're always saying there needs to be an independent investigation. There needs to be, if they find evidence supporting a prosecution, that needs to happen. Prosecution needs to happen. The process the jury needs to be selected in a way that is fair. It needs to be a jury of peers and diversity on the jury. And then when the verdict comes out, whether I like it or not, I always make sure that we're clear that we don't denigrate jurors, right? Because again, we're talking about the system. But as I told President Obama and President Biden, at some point when it never works, or almost never works, we lose credibility. And there's not much I can say. I said to them, you should be supporting, you should be supporting me. I'm trying to hold belief in a system, but I'm also not going to undermine my own credibility by pretending that the system actually does work when it doesn't. So those are the things we have responsibility for. Don't we want, our children and our communities to believe in the legal system? But what if they can't believe in the legal system? Why do we, almost every week in this country, I'm sure all of you see it, someone is released from prison who's been in prison for 20 years or more for a crime they did not commit. We don't even blink about it anymore. It's not even the top story. It's every week, 18 years, 8 years, 20 years, 36 years. And the first question the media always asks them is, are you angry? No, we should be angry. And our profession should be angry that these miscarriages of justice happen. Why do we have Brady violations that continue to this day? Why don't prosecutors, take seriously in some jurisdictions the obligation to comply with Brady and provide exculpatory evidence to the defense? The things that we brag about the American legal system are not about how many people we have in jail and how many prosecutions and how many people we execute. When many of you go on delegations and meet with lawyers from other countries, you talk about the right to counsel, you talk about the right to face your accused, you talk about the impartial judiciary, you talk about a jury of your peers. Those are the things we brag about. Everything that's associated with the defense and fairness to someone accused of a crime. And yet, until this past administration, the route to becoming a federal judge was to be a prosecutor, to the point that if you had been a criminal defense lawyer, there was very little chance that you could be nominated to serve as a federal judge. Those are the imbalances that we need to be attentive to as a profession. That's not a layperson's job to understand what that imbalance can mean for how the law is interpreted, for how we think about the law, and so forth. We should understand what it means to have a Supreme Court that is not diverse in that way in terms of professional background. And so those are the things I think we have to grapple with. We have the ability to examine it and look at it. I think the question, Donna, is what stops us from doing it?
You wrote a very searing op-ed in the New York Times of February, a year ago, where you posed, you basically was an indictment of our profession, where lawyers enabled Trump's worst abuses. That was clearly you taking the opportunity to talk about what you saw because it was so important, and to challenge all of us to speak in situations where we believe that injustice is being done. But still had to have been a bold move for you to do that, because I would imagine that you were subjected to criticism and accused of being partisan. And that accusation of being partisan is one that's often used to shut down discussion. Can you talk about that a bit, and how we need to be able to move past it to actually have conversations about facts, not party positions?
Yeah, I mean, I first of all run a nonpartisan organization, and I mean that. I mean, I fairly regularly sue the governor of Louisiana, who's a Democrat, in voting rights cases. Listen, I sued Bill Clinton, when he was governor of Arkansas in Jeffers versus Clinton, a very important voting rights case, in Hunt versus Arkansas. We started our voting rights work with Thurgood Marshall's first successful case, which was Smith versus Albright, which he won in the Supreme Court in 1944, which struck down the use of the all-white Democratic primary. We don't care who it is. In those days, it was the Democrats. In these days, sadly, it's the Republicans. I'm not going to lie about that. Up until 2006, it was, the issue of voting rights was nonpartisan. The reauthorization to the Voting Rights Act passed in 2006, 396 to 33 in the House and 98 to 0 in the Senate. So I haven't moved. I can't help that a political party has moved. That doesn't make me partisan. And that's why I told the story about the Ken Starr, argument at the beginning, because that's not where I'm coming from. So you're right, you've identified one thing. One is the fear of being called partisan. The second thing I think is important is, and it's hard, it's tricky. It's the unwritten code of gentlemanly regard and sisterly regard within the profession. I'm not trying to get rid of that, but it makes us loath to call others out. And we've seen this. We've seen this now with, some who are speaking out about sexual harassment in judicial chambers and things that were verboten. But I will tell you this, if you are serious about ensuring that your democracy remains and is healthy, and I do hope people understand that that's not a foregone conclusion. All of us on this call will probably be just fine. That doesn't mean that we will be living in a healthy democracy. And I hope people understand that. But in order for the democracy to be healthy, you have to be willing to grapple with difficult things. And I will just say this, I'm a quite reasonable person. My husband always says I can talk to anybody. It's true, especially when I was a football fan. But I had to do uncomfortable things too. In the 81-year history of the Legal Defense Fund, I think we sued the federal government twice. During the Trump administration, we sued 7 cabinet secretaries, and the president. We sued the president under the KKK Act for the activities after the last election in the effort to try to get people in Detroit and Philadelphia and Atlanta to reverse the outcome of the election. Do you think that was easy or comfortable for me? Some of us are not even able to live in our own homes because of the threats that come against us doing this work. So we have taken risks. I have spoken out in ways that I think are right up to the line, of what I would be prepared to say publicly, because I too am conscious of that. We appear before judges. I accepted President Biden's nomination to the Supreme Court Commission, and I've got a cert petition pending there right now. But because he assured me that this was not a commission that was going to be partisan, that it was going to comply with the rules of FACA, the Federal Administrative Committees Act, that requires the committee to be balanced. And so there would be people of all viewpoints, and that we would not make recommendations about court packing and so forth. And so but I did it because I thought, put your money where your mouth is. Here's an opportunity where people are going to be talking about, people of different viewpoints, talking about how to strengthen the procedures and practices of the Supreme Court. And I do believe that some of them need to be strengthened. I spend a lot of time talking about the shadow docket and what it means to my client to have the decision-making happen behind the veil. And so I took that on, but that wasn't easy. That wasn't an easy decision to make. I had to talk to my senior team about it. Did we think it would imperil any of our litigation? So I'm not asking people in our profession to do anything I haven't myself done. And but I believe that that's what's required of us in this moment. We all get handed our moment.
Certainly, lawyers have never been accused of people who are shy about voicing their opinions. And from what you're saying, this is not the time for us to be quiet. We need to speak to each other and speak publicly when we have concerns about what we're observing. We see.
And by the way, Donna, I just want to say, I say the same thing to journalists. I think the media needs to do its own self-examination. Political parties need to do their own self-exam. I mean, there are multiple areas that need to be engaged in this, but I'm speaking to the one I'm part of.
Right.
The one we're a part of. Let's start with ourselves.
So, and I'm thinking about even the medical profession now, where you're seeing there is a movement with the organized medical associations to address what they see as misinformation that's being put out there by other medical professionals and saying that really is a violation of their obligations, and we should be doing the same when it comes to calling out lawyers who are participating in putting out disinformation and misinformation and compromising the integrity of our institutions. So what we really, this has been an amazing conversation, and would love to hear if you have a specific charge for us as we move forward with these conversations, accepting the mantle of being guardians of justice, understanding that our profession thrives and survives if we have shared values, and that is core to who we are. Is there a message that you want to be received by our community as we move forward with hopefully more conversation around these issues?
Yeah, we're the guardians of our profession. I remember when I was admitted in New York, and the oath was a fairly brief thing about upholding the Constitution, but I actually liked Maryland's. Here's what Maryland says. So everybody who is a lawyer on this call actually took this oath. And I know some of us are so old we don't remember it, but here it is. I do solemnly affirm that I will at all times demean myself fairly and honorably as an attorney and practitioner at law, that I will bear true allegiance to the state of Maryland and support the laws and Constitution thereof, and that I will bear true allegiance to the United States, and that I will support, protect, and defend the Constitution, laws, and government thereof as the supreme law of the land, any law or ordinance of this state or any state to the contrary notwithstanding. I mean, this is about, how we demean ourselves. It's about honor. When we tell people you're an officer of the court, you can't mislead the court. You can't lie to the judge. You can't make frivolous claims. You can't. And so I think it's really important that we police the boundaries of our profession and take it seriously, and that we do a historical examination of where we have gone wrong, that we take seriously the need for our profession to operate at the members of our profession to operate at the highest levels, that we speak out as a bar about what we think is right and what we think is unacceptable, that we teach young people what it means. And I say young people, I mean new lawyers. I taught for 20 years. You know, in 20 years of teaching, I had no idea you could just ignore a subpoena. That's not something I ever learned.
That's a new one.
Is that what people on this call learned? How come we're all silent about it? How come we aren't saying anything? If you're a young law student or lawyer, what are you to think? Are you to think that it's okay? But there's been no collective response just to that one issue, that I thought was, you know, something that we all understood. I remember when President Trump said something about a judge, I guess this was during the early part of his campaign, that, you know, he's not going to vote for me, he's Mexican. And so he, you know, I'm trying to build a wall. I mean, every bar association should have issued a statement of condemnation of that kind of remark. Has nothing to do with partisanship. Has everything to do with a despicable aspersion on the impartiality of a judicial officer based on his race. There are these moments that just call for it. And talking about it at your friends with brunch, with your friends at brunch, is not it. We are the guardians of this profession, and we have to stand up and speak when it's required.
And again, give you opportunity to also speak to law firms and what roles they have in being part of this responsibility.
Well, absolutely. I mean, some of these judicial nominees that I spoke of who refused to say that Brown versus Board of Education was correctly decided or was constitutional came from some of the finest law firms in the country. What are we talking about at the brown bag lunch? I would like to know. These moments happen where people are denying that they need. I mean, you can believe that a subpoena, you know, that you should not have to produce, and you could show up and explain why and say what your privileges are, but you can't just ignore it. Are you all talking about that? Is there a brown bag lunch immediately after that happens so that young associates understand what is and what is not to be done? When you see, you know, lawsuits being shot down as they were after the election with wild and frivolous claims being made in open court, what are you communicating, law firms, to young lawyers? Are you telling them this is right and this is not right? That you can represent your client zealously without crossing the line, whoever your client is. When someone is released from prison, who's been in prison wrongfully for 20 years, do you all just keep it moving at the firm? Because I know you all have lovely pro bono practices, and many of you work with the Legal Defense Fund, thank you very much, and on death penalty cases and others. Do you talk about that? Do you talk about what that means, what a blow that is, what a stain that is on all of us and on this country? So we talk about it all the time at the Legal Defense Fund. So I think it's really important that you have these conversations and that we be serious about what we claim are the rules of engagement in our profession. You know, the words judicial temperament are nowhere in the Constitution, but somehow we decided that that's a quality that a judge should have. And so when we see that not happening, what do we have to say about that? So we have the ability to address all of those things within the profession, in our law schools, in our law firms, in our bar associations. We have the spaces where we should feel that we can, as a unified profession, talk about these things.
And I think you've also been very thoughtful in that editorial that I referenced, where you have some even more things to talk about dealing with specific observations you made about where lawyers have fallen short. And I really would encourage everyone to take a minute to look at that. One of the things being for us to question whether or not the rules of professional conduct really are expansive enough to cover some of the things that are important to our reclaiming our shared values and our code of conduct and how we're going to engage with each other. You know, there's never enough.
There were norms so there were things we thought didn't have to be written down. You know,
well, that's true.
Maybe some things have to be written down now. Maybe as we're watching people blow through norms, you know, there's ethics and there's norms and there's laws, right? And maybe we need to tighten up. Maybe we need to look back at our code and think about things we need to say more explicitly rather than assume. We don't want to inhibit zealous representation by any stretch of the imagination, but it's worth a look. It can't harm us. to look at it.
Certainly in the medical profession, they do mortality and morbidity reviews when things go not as expected or don't go well. And I don't know that we even have conversations like that, but perhaps all of these things are things that we should be looking at, because we certainly need to, this is where we need to take a stand. And I so appreciate that you have engaged in this conversation. It really could go on and on and on, because there's so much to say, but I want to be respectful of your time. There were some questions that people wanted to ask. Do you have a minute for a question or two?
Sure.
Okay. This is from a law student, your former law student, who wants to know if you would speak to the mental toll that several of the violations of civil rights takes on attorneys, both in the terrible incident as well as prosecuting the case, especially in the public eye.
Yeah, this is not easy work. It can be incredibly strenuous and difficult. And that's why it's so important to have a community of people who are committed to this work with you. I always say about the Legal Defense Fund, you know, we work incredibly hard and it can be incredibly difficult, but we have a great time in some ways, because there's such an esprit de corps, even remotely, among us. There's such a sense of shared mission. We never have given up our sense of humor. You know, I always say about our founder, about Thurgood, that, you know, he always wore it lightly, you know, and I think I've tried to follow in that. You know, he had such a great sense of humor, and to also just, you know, respect that this is exhausting work. I did something last year in March that I had not done in 9 years of leading the organization, that I'd never imagined doing. I just closed the office for a week. I could just see it. You know, we were going to start strategic planning, and I knew what our staff had done in 2020. We had worked around we didn't stop 1 second. I mean, I remember we went remote very quickly, and we had a trial, a big trial in Florida in April. And it was, you know, we went remote in March, and now we had a trial the next month, and our attorneys had to learn how to put on witnesses, how to prepare witnesses remotely, how to enter exhibits. It's nothing that's ever talked about. Where's that conversation in our profession? I mean, it really took a toll for them to do it. They never complained. They just learned how to do it. And we did multiple trials. We argued in the courts of appeals. We're still doing trials. But, you know, it was an incredibly strenuous year, right up to the very end. And then we started the new year, and January 6th happened. And then, you know, voter suppression laws started to be passed, you know, around the country. And so we didn't get a chance to breathe. And I could see the toll. And I just said, you know what, this is not your vacation or anything. You know, those who have pressing litigation matters and can't take this particular week off, you get 5 days, but you have to take it by April 30th, you know, and everybody just needs to breathe. So I do think to the, you know, the question, supervisors have to be sensitive to the toll that this period is taking on young lawyers. We have our own personal lives too. Our lawyers at LDF, unlike in my day, I was the only lawyer when I was at LDF who had, certainly the only woman lawyer who had a young child. As a matter of fact, I had my first child my second year at LDF while I was litigating. And so that stayed with me. And so we're very sensitive to that. We have a generous parental leave policy, and we try to be really conscious of people's needs for their families. And that's important for law firms and for our profession to recognize that too, that this has been an incredibly strenuous period. And when you see injustice, you know, day in and day out, it really can take a toll. And you need beauty in your life too. I'm a big, you know, art and theater person because I need to be able to get away. And I often can't physically get away, not because of COVID, but sometimes I just can't get away from the work. And I need that 2 hours in the theater to enter another world. I need to read a novel so that I can enter a world that is completely different than the one that I'm in. And so it's important to keep nurturing yourself, and for those you work with to recognize that that we all want longevity in this work because there's a lot to do, but we have to take care of ourselves.
And maybe one of the things we can all be supportive of lawyers who are on the front line doing that work is by doing our parts. So maybe you don't have as much business to attend.
It'd be lovely.
Yeah. Well, I think that's going to have to be it for this part of the program. And again, I can't thank you enough on behalf of everyone who was involved with this program, but more importantly, all the people who showed up tonight, both here in the Zoom and on YouTube, for your taking the time to come and speak to us. Your words are very important. They're very powerful. And certainly I'm prepared to make the kind of commitment that you have encouraged us to do. I just want to thank you deeply for giving us this much of you at a time where I know you have so many other things to do. Right?
Thank you so much. And I really also just am filled with, just admiration for the fact that you all are doing this series, which I think is so important. And, Maryland is my home. I'm sitting right here in downtown Baltimore right now. And I care deeply about this state and this profession and our bar in particular. And when I get off this call, I'm going to be speaking to corporate leaders because the business profession also has to do some soul searching about this moment. So
absolutely.
I'm
You've
very
given us
pleased that you all are
a good lead.
good.
I'm going to turn it over to Rena now, who's going to tell us what to do because she's the big boss.
Almost speechless. It's hard to talk. So thank you so much. That was stirring and rousing and, just a great reminder and a great call for all of us that care so much about this. So thank you deeply from us to you for joining us.